Thank you, Mr. Chairman. H.R. 1789, the Promptly Ending Political Prosecutions and Executive Retaliation Act of 2025, would place a check on radical left-wing prosecutors, or really any prosecutor's ability to bring politically motivated criminal cases before judges and juries that may be biased. The last few years have brought about outrageous and unprecedented moves from rogue prosecutors to target one of our nation's top leaders for their own political gain. For the first time in American history, a former president was indicted and faced with criminal charges. After President Trump announced his 2024 presidential campaign, he was indicted not just once, twice, or 3 times, but 4. And 2 of these indictments have come from rogue district attorneys looking to build up their profile, as this committee has explored last Congress, and make a name for themselves on the national stage. In April of 2023, Manhattan DA Alvin Bragg announced a 34-count felony indictment against President Trump in the New York State Supreme Court. Instead of prosecuting real crime in New York, as we witnessed in this committee, that they continue to face, DA Alvin Bragg made President Trump the focal point of his campaign. And then again in August of 2023, Fulton County DA Fani Willis brought about a 41-count indictment against 19 defendants, including President Trump, in the Fulton County Superior Court. Willis even told the news outlets, quote, "We've been working for 2.5 years, we're ready to go," end quote. They could have brought charges years earlier, but decided to do it as soon as President Trump announced his re-election campaign. These politically motivated district attorneys did everything they could to keep Donald Trump out of the White House, and well, we all know that it backfired as the American people gave President Trump a resounding mandate to restore our country's greatness. The American people saw the political persecution led by the Biden-Harris Justice Department's 2-tier justice system that extended to Democrat, local, and state offices. These were bogus indictments, and our rule of law must be protected. The president is the leader of the free world. The level here is not the same. A small-town prosecutor coming in and attacking our commander-in-chief is laughable. We don't do this in America. We never have. And we can't continue to allow America to turn into a country where candidates running for office are prosecuted out of purely political reasons. These prosecutors have weaponized our justice system against its political opponents, and it is Congress's duty to respond, which is why I have introduced this bill and a similar bill from last Congress, which would give both current and former presidents and vice presidents the ability, not a mandate, but the ability to remove their civil or criminal cases against them from a state court to a federal district court. The new bill also expands the eligibility to remove cases also to current and former U.S. officers who are acting within the scope of their official duties or apparent legal authority related to their office. The bill also codifies the immunity recognized by the U.S. Supreme Court for official acts carried out by federal officials. The federal interests implicated by civil actions or criminal prosecutions brought against current or former presidents and vice presidents are pretty overwhelming. A federal court is the appropriate forum to adjudicate cases with such a strong federal nexus. Federal judges, as an example, enjoy life tenure that is largely free from outside interference in their decisions. By contrast, state court judges are readily subjected to political influences, as many of them are often elected or directly appointed or serve shorter terms. In federal court, the jury pool is often drawn from a larger and more diverse district. The rules of jury selection are much more robust than in state court. This helps to ensure that the political biases of one locality do not improperly influence the jury and its decisions. So we must ensure that state courts are not weaponized against current or former presidents, vice presidents, or U.S. officers. This is common sense. We can and should act to provide this option of a fair playing field for legal proceedings for all presidents, vice presidents, U.S. officers, former and current. I urge support, and Mr. Chairman, I yield back.
The gentleman yields back. We now recognize the ranking member for his opening statement.
Mr. Chairman, thank you very much. So the legislation before us today would amend the law so that a president or vice president, or even a former president or vice president, can remove any state civil or criminal prosecution when that case is brought, quote, for or relating to any act while in office. Okay, any act, whether it's public, private, official, unofficial, within the core functions office, within the outer perimeter, or having nothing to do with the office at all, for any act while in office, or where the state court's consideration of the claim or charge may interfere with, hinder, burden, or delay the execution of the duties of the president or vice president. In other words, every conceivable case will be removable. So look what we're talking about. And I hope my Republican friends will listen as well as the Democratic members. We're talking about destroying state criminal jurisdictional authority and power over federal officials. That's really what this bill is about, because it's saying that the president or vice president or former president or VP can never be prosecuted because, of course, it could conceivably hinder the execution of their office. Of course, it's any act, one office. So what we're talking about is, should a president or vice president ever or former ever be able to be charged with a state crime, including assault, rape, murder, fraud, you name it. And they're basically saying no, that has always got to go to the friendlier terrain of a federal court. So let's remind ourselves of what the genesis of all this is. On May 30th of last year, Donald Trump was convicted in New York State Court of 34 felony counts for falsifying business records to hide his hush money payments to women who he'd had an affair with. When he tried to have the case removed to federal court, the judge found that, quote, hush money payments were private, unofficial acts outside the bounds of executive authority and thus not subject to the constitutional removal requirements. It had nothing to do with his office, and the defense was not a federal defense. It was just a conventional alibi defense that you would find in the normal course of things in a state court. Trump also has charges pending against him in Georgia state court after Trump called the Georgia Secretary of State, Brad Raffensperger, famously asking him to just find me 11,780 votes. He was charged with election subversion and racketeering under Georgia law. He withdrew his application to remove his case to federal court after his co-defendant, our former colleague Mark Meadows, was found not to have met the quite low threshold to move his case to federal court, and that the actions outlined in the indictment were not taken as part of Meadows' role as a federal official. In other words, there was no federal defense available, making this a federal question. Last time this bill appeared at a markup, candidate Trump was just starting his campaign. He'd not yet been convicted of those 34 felony counts. His co-defendants had not pled guilty. In 2023, this was simply a bill to get the cases against him out of state court and into the federal system where Trump and his lawyers could try to shop for the judges they wanted. Today's bill looks very different because House Republicans have a new goal. They want to make sure Trump is not held to the same standards as anybody else, in essence, that he's above the law. My colleague's solution to Trump's personal legal problems, which were created by him, is not to make him all but untouchable in the American judicial system. This bill would require a federal court to dismiss any case against the president or vice president or former president or VP that becomes subject to removal, and that's any case in the state court system. The 2025 version of this bill is an autocratic Christmas tree designed to ensure that nobody in Trump's orbit, from Trump and J.D. Vance to Elon Musk and Mark Meadows, is held accountable in state court. That is completely incompatible with the idea that none of us is above the law. It's an assault on states' rights. It's an assault on federalism. It's incompatible with the Constitution, and it does not do justice to the hard-fought principle that nobody in America is above the law. I oppose this bill. I encourage my colleagues to do the same, and I will yield back to you, Mr. Chairman.
I thank the ranking member for his opening statement. The chair now recognizes the gentleman from South Carolina for the purposes of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 1789 offered by Mr. Fry of South Carolina.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair now recognizes the gentleman from South Carolina to explain his amendment.
Mr. Chairman, this amendment adds the year to the title of the bill, and it's not intended in any way to alter the substance of the bill. I yield back.
Who seeks recognition?
Strike the last word.
Mr. Chairman,
I have the
I have an amendment at the desk.
Sorry, never mind.
We'll take the strike the last word first, if that's possible. The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. We discussed this bill yesterday in what we are hearing, and it made me think of critical race theory. Critical race theory is about educational, scientific, historical knowledge of the past, which some people think is disturbing because it disturbs them to think that we had slavery in this country, that we had Jim Crow for about 80 years, that we didn't allow blacks to vote forever unless they could count all the peas in a jar. So we got a critical race theory. We didn't like the idea that we killed so many Native American Indians and it was almost a genocide. We want to get rid of that too. This is critical law theory. The Republicans don't want people, and Donald Trump doesn't want people to know that he is a convicted felon. And he wants to find any way in the world to end that. And he wants to say, I didn't do anything wrong. I'm perfect. I'm the greatest guy in the world. Everything happens with me. He got convicted on 34 counts, felonies, by juries that every single juror said guilty, 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 guilty. Donald Trump is guilty, and no matter what you do with this law, he's guilty, and history will record it as such. But what you're trying to do is do his work to have critical law theory and to erase what is a fact in courts. The state court did it in Georgia because, yeah, that's where he called the governor and said, just find me 10,734 votes. I want to change Georgia's election. I want you to cheat in Georgia and get me some votes so I can have the votes to become president. That's a Georgia case. He was interfering with Georgia state election and Georgia state law to get Georgia's electoral votes. Should have been in state court. But no, Donald Trump doesn't want anybody to think he did anything wrong. So he wants to remove it to a federal court and maybe get it into a court with a judge like Eileen Cannon that'll go, yes, Mr. Trump, what you want? That's what they want. They want judges who have no guts, who have no respect for their oath of office, like Eileen Cannon, who embarrassed us with putting off the classified documents case, and who repudiated by the Court of Appeals. They found her actions to be sophomoric at best. These bills are absurd, and for us to be doing them shows us to be supplicants. We take an oath to support the Constitution. Yeah, we can change laws, but this is about critical law theory. Critical law theory. No, Donald Trump did nothing wrong. Donald Trump, in fact, should have been on the Supreme Court because he's smarter than everybody. He knows the law and never would violate it because he knows it better than any of us. Well, BS. I yield back my time.
Will the gentleman yield? Will you yield?
Yes, I yield to Mr. Goldman.
I thank the gentleman. I have a question for my colleague, Mr. Fry. If this is removed, if a state case is removed to federal court, what law applies?
Well, it's the state law, but the process is under federal jurisdiction. So we already do this for ambassadors, for members of Congress. That's how the current law exists as it stands. And so this would extend those the same federal statute to former members, or excuse me, former presidents and vice presidents, obviously.
Right. I mean, I think the law would still apply. The same federal question doctrine still applies. This bill is very clearly designed not to actually correct a problem, but to simply defend Donald Trump and perpetuate the absolute whitewashing that the Republicans have doubled, tripled, quadrupled down on in fealty to Donald Trump, that somehow these were political prosecutions and investigations. And the only evidence of that is that the defendant said it. That's all you have. You have no actual evidence of any politicization or weaponization.
Well, Mr.
If you look,
Sir,
I reclaim my time. If you look at the actual indictments, if you look at the Mar-a-Lago search warrant, there is not an objective judge, prosecutor, or anyone else who understands criminal law who would say there's not enough evidence to charge or to go forward with a search warrant. And all you are doing is trying to create a monarchy for Donald Trump. And that's what you have been doing by yielding all of your power to him for the last 6 weeks.
The gentleman's time has expired. I now recognize the gentleman from South Carolina.
Let me just write the last word.
The gentleman's recognized for 5 minutes.
Thank you. I was going to respond. You said that this was not, Mr. Goldman, this was not politically motivated, but we know that to be the case. In fact, you live in the jurisdiction of Alvin Bragg. You campaigned with Alvin Bragg, who campaigned on going after Donald Trump.
False.
And so to
He didn't.
say-
He never campaigned on going after Donald Trump.
To say
gentleman
that this
from
was
South
not
Carolina's
politically
time.
motivated is not based in reality. This absolutely was. There was coordination with the Biden DOJ. That was both in the Georgia case and the New York case. And so to say that it wasn't and that we're just making it up really kind of goes against the overwhelming evidence to suggest that that's exactly what they were doing to begin with.
Will the gentleman yield for a question?
With that, I yield back to the chair.
Would the gentleman yield for a question?
No.
To me.
To you, Mr. Chairman, of course.
So many questions, so little time. So there were a few things said, and I want to understand so that everyone understands. Currently, a federal judge whose a similar event occurs would be removed to federal court. Is that correct?
Correct.
And if there's ever been a friendly venue, it would be for a federal judge in a federal court. And yet that's been the law for a long time, right?
Correct.
And currently, if it were you or any of the gentlemen on the other side, it could be removed to federal court in many cases.
Correct. And again, it's not a mandate. It's an option that you could remove. And so it is up to the defendant in a civil or criminal case to take that option to remove.
And for those who haven't practiced in federal court, it is not uncommon for federal judges to be overseeing cases that include state causes.
Would the
correct?
gentleman yield?
For sure, yes.
Okay, so there's nothing unusual here. It applies to other federal offices.
Issa, yield.
Just one second. We're extending it only to the president. Let me go through a couple of pieces of history, though, if I could, and ask you questions. President Obama ordered and struck an American citizen on foreign soil and killed him. You remember that?
Yes, Mr. Chairman.
Okay. Terrorist, but he wasn't currently shooting at us or anything like that. He was tried, I guess, in the international court, but we didn't recognize that. Nobody, picked a state where this terrorist was from and tried to prosecute the president. But if they did, without this law, isn't it conceivable that it wouldn't be removed to federal court and you could have a venue that somehow would think they could try the president for his official acts?
That's exactly right.
And the gentleman was referring, I think the ranking member was referring to this idea of dismissal. Is there anything here that dismisses cases that is not consistent with the U.S. Constitution based on, or with the decision of the Supreme Court?
No, I think that goes beyond the bounds of the legislation. This is just a removal mechanism. This isn't a removal and dismissal mechanism.
Okay, now, not having been in district court all over the country, would this case be removed in the jurisdiction in which the state occurs? In other words, if it's in Georgia, would there still be a Georgia federal court hearing it? It wouldn't be removed somehow to Nova Scotia, right?
Correct.
Or Greenland.
Correct, Mr. Well, unless they're the 51st state.
Okay,
we'll
so
see.
just for people that haven't, served on a lot of juries, the pool of federal juries in Georgia is the same pool, whether it's state or federal, correct?
Correct.
So the same individuals would try. The only question is, do the ladies and gentlemen on one side of the aisle don't trust federal judges, but they trust local judges who run for office versus federal judges?
Right. Correct, and have all the potential for political influence based on donations, based on political party and the like.
Okay, so really all you're doing is removing it from the political process to an apolitical process and keeping it in the same geographic area that the case is brought, but removing it to federal court.
Correct, and if you, and as an accomplished lawyer yourself, Mr. Chairman, you know that the jury selection in a federal system, the defendant or the plaintiff know much more about the potential jurors, potential biases, the potential to obviously strike those jurors. You want a fair and impartial jury. You know much more about those jurors in a federal system because the system is much more structured than in a state court. State court, you show up and the jury pool's there and you're oftentimes trying to use your best judgment on who would be a fair juror. And so this, again, gives the former president, the former vice president, the option to remove if they so choose.
And isn't the former vice president still limited to this provision of the interference? In other words, it's not everything. It's based on acts related that could, a former vice president, acts relating to any act while in office. So it's not for life on former presidents, right? It's just for those, for the acts while in office.
Correct.
I thank you. And thank you for yielding.
Thank you, Mr. Chairman.
Who else sees recognition? The ranking, you wanted to hit him?
I think everybody's gone. Are you?
At some point, I would like to move to strike the last word, but I defer to the ranking.
Out of deference to the ranking member of the full committee, I recognize him to strike the last word.
Thank you, Mr. Chairman. I'm just going to follow up on your line of questioning, and then we can go to Mr. Goldman. If the gentleman from South Carolina, if he could come back, if maybe someone could get him to, I would love to pursue the questioning. But here's where I'm going with this while they're getting him, Mr. Chairman. I think you asked exactly the right question. You were saying all this is a removal provision, right? But it's not just a removal provision. It's a removal and dismissal provision. If you look at E on page 5 of the bill, it says, in any action subject to removal under paragraph 5, which is current president or vice president, or 6, which is former, of section 1442A, such case shall be dismissed unless rebutted by clear and convincing evidence establishing that the continued pendency of the state claim or charge would not in any way interfere, hinder, burden, or delay the execution of the duties of the president or vice president. And what I'd like to ask the distinguished gentleman from South Carolina is, can you imagine any case where a president or vice president or formers would lose that in saying this is going to hinder or burden or delay my execution of duties? Who wants to be in a criminal prosecution of any kind? So it's a guaranteed removal and dismissal, because it must be dismissed, it shall be dismissed, unless you can prove it's not going to affect their life in any way.
Would the gentleman yield?
By all means.
I would agree that if you took it out of context, just looking at it here, but the context, I hope we all agree, this is a Supreme Court ruling. We're codifying what the court has already said. And as to a former member, which the president was when charges were brought, the standard would, by definition, be different because he wasn't executing his activities during those 4 years. So the actual dismissal of those cases—
Just reclaiming my time for a second, if that's true, then why should the logic of this apply to him at all? Why should it apply to former officials in any case?
Because the removal would apply, but not the basis to dismiss. That's where the two, as the gentleman probably knows, currently Prime Minister Netanyahu spends 3 days a week in court because they have no such law in Israel at a time in which he's defending his country in a war. We're seeking to make sure that we minimize to the greatest extent possible 50-plus states in which people could bring cases against a current president. And if they bring it against a former president for acts while in office, limited to acts while in office, that it simply be removed to federal court. But I think the Supreme Court decision on dismissal is very different for a former president because they don't meet that standard of hindering his execution of his job.
Okay, well, just to reclaim my time there, if we're talking about a former official, it shouldn't apply at all because they're no longer in office. In the New York case, Trump claimed that it interfered with his presidential duties, nonetheless. But look, I would say this. This shows spectacular disrespect for state courts, state constitutions, state prosecutors, and state law. I mean, I'm really shocked that this is even something we're considering to obliterate state criminal jurisdiction over crimes that exist within their state. And if they're, in some ways manufactured or invented, the state systems are just as capable of vanquishing the fantasy prosecutions as a federal court is, and much better at interpreting and enforcing state law than a federal court would be. And yet—
Gentleman yield?
Yes, I would.
I just wanted to clarify, one of the gentlemen on the other side said that the state judges are elected. Some are, many are appointed, just like federal judges.
That's absolutely right. And so, I mean, this does reflect a basic structural trampling of state court and state legal systems. But I think that the really sneaky provision is this dismissal one, because the overwhelming presumption is that it will be dismissed the moment you get it into federal court, unless you can somehow prove that this will not in any way affect the performance of the duties of the president or vice president. And if they're no longer president or vice president, why are they getting the benefit of this in any way at all? So I do agree with Mr. Goldman that this seems like a very political bill that's just meant to curry favor with, or perhaps soothe the hurt feelings of Donald Trump. He was in those situations because of actions he did. He was the one who said, just find me 11,780 votes. Nobody else made him do that. He made his staff go ahead and call Secretary of State Raffensperger. He was in trouble in New York because of the hush money payments he made, and then he cooked the books in New York. That was his decision. I mean, let's show some civic self-respect here and acknowledge that people are responsible for their own actions. I yield back to you, Mr.
I
Chairman.
thank the gentleman who else seeks
Move to strike the
recognition.
last word. I move to strike the last word.
The gentleman's recognized for 5 minutes.
Thank you. I want to just pick up on what the ranking member was saying, and a couple of things. First of all, this is not simply codifying a Supreme Court decision, nor is this removal for a federal court to consider a state law claim. And I would point my colleagues to page 4, section B1, for determination of immunity, saying the nature, elements, or any other aspect of the charge or claim made by or under authority of state law. Basically, any state law claim is immune. So it's not interpreting state law just simply in a federal court. If you want to bring a bill that simply clarifies that the rule for judges and members of Congress should be the same for federal official, the president and the vice president, we can discuss that. This is nowhere close to that. This is going even further than the Supreme Court case, because it also addresses civil cases, not just criminal cases. And it also expands the immunity through both dismissal, as the ranking member pointed out, and there are other references to dismissal, but beyond what the Supreme Court says. But even more importantly, it goes so much further than what you're representing. And I would just urge my colleagues not to continually overreach in fealty to Donald Trump. We are happy to discuss thoughtful, reasonable legislation that preserves the rights of a president and a vice president. Why are former presidents and vice presidents even included in this?
Will the gentleman yield?
Yes.
I've got one theory about that, but I would love to be illuminated by someone on the other side of the aisle. But Donald Trump in the New York case was saying that even though he was no longer president, the fact that he had to stand trial interfered with the fact that he was running for office again and was involved in other political activities. So I think they put in former presidents and vice presidents in the event that they wanted to be running for some other office.
Right, and of course, if you expand that to its logical conclusion, every one of us is always running. Always running. So if the argument is, oh, well, you can't charge a elected official or former elected official because they're running for office, Donald Trump very clearly announced his campaign extremely early and previewed the fact that he was doing it so that he could argue that these investigations against him were interfering with this. This was a defense that he created, and then everyone on the other side of the aisle bought into it. But I do want to just answer my colleague from South Carolina on the New York case, which I would point out there was no assertion or allegation that the special counsel's two cases there was any evidence of politicization. He did not mention the Georgia case, so let's just focus on the New York case. Alvin Bragg never campaigned on getting Donald Trump. Never said, I am going to get Donald Trump, I am going to go after Donald Trump. Never. If you have a quote of his, please, I urge you to bring it to me. Never happened. False. Secondly, I don't know what coordination between DOJ and the Manhattan DA's office you are talking about, but I can tell you that as a federal prosecutor for 10 years, I coordinated, I spoke to state prosecutors all the time. We shared evidence all the time. That's how prosecutions work. Sometimes you will charge it in state court, sometimes you will charge it in federal court. But I don't even know what allegations you're talking about. I haven't seen any evidence, any actual support, other than the fact that a former DOJ official joined the prosecution team in the Manhattan District Attorney's Office. I don't understand how that is the DOJ coordinating. He's no longer with the Department of Justice. But you keep making these allegations and you have no support. And it's as if you say it enough times, it just becomes true. But that if you say it enough times, that doesn't mean there's any evidence to support what you're saying, and your allegations are baseless that any of those prosecutions was politicized. And I yield back.
I now recognize myself. I asked that pages, that an excerpt from page 24 of an actual hearing, perhaps you weren't there in New York, but the quote is, let's talk about what's waiting for the new DA, the docket. We know there's a Trump investigation, okay? So here is the reference that came out of it. On March 17, 2021, Bragg indicated that if elected as district attorney, he, quote, will hold Trump accountable. Just a few days later, on March 23, 2021, he again boasted that he had sued the Trump administration over 100 times. In June of 2021, Bragg doubled down, stating that the important work that separate from any that the DA office may be looking at now. In other words, Bragg assumed office with seemingly one goal: to prosecute President Trump.
Will the gentleman yield?
I will in a moment. To say that this wasn't a determination, that he didn't cobble together misdemeanors to create a felony, that he didn't invent something that, quite frankly, had never been done before, that he didn't work around a statute of limitations, is laughable. Having said that, I'm going to, because the gentleman asked me to yield time for a question, I'm going to just ask one question. All we're doing is modifying federal law. Federal law in the state above that, because he kept quoting from 28 USC 1442, it applies to any officer of the courts of the United States or related to the act under the color of the office or performance of the duties. 4, any officer of either House of Congress or related to any act in the discharge of his official duties in the order of the House. Would the gentleman suggest that we strike both of those? Would the gentleman take away his own ability to remove or the judge's ability to remove? Because all we're doing is adding other federal officers and ultimately covering what I think is a branch not covered by this 28 USC 1442. Would the gentleman respond, please?
Yes, and as I mentioned to you, if that were simply all this was doing, I would be happy to discuss this in good faith.
Would the gentleman agree that adding the decision of the Supreme Court, and he did reference the basis for, on page 4 for the basis of immunity, and reading it carefully, I think the gentleman will find that what it actually does is that it states that for purpose of determining the immunity, you will not look at the nature of the charge. And the gentleman did say, what about murder? Well, the question for it would be, was it official act? And I cited President Obama's ordered execution of an American citizen without a trial or a grand jury or any other indictment for actions. The fact is, a state court could have brought charges for that. In this case, it would have been removed. The court would have decided that, in fact, the commander-in-chief made that determination and he had immunity. I'm not disagreeing with the court. What I'm saying here, and Mr. Fry's bill clearly says, is it's to be considered in federal court, and the immunity question is not a question
Would the
that
gentleman
is
yield?
automatically dismissed.
Would
It's
the
a case.
gentleman yield?
Yes, I will, consistent with the Supreme Court ruling, yes.
I'll defer to Mr. Nadler.
Thank you. What President Obama did was an official act. If what President Trump was convicted for was not an official act, if anyone at this table, in this committee room rather, violated the state law by committing murder or by theft or by fraud, he'd be tried in the state court. That would be removable.
I agree with the gentleman that the allegations were not an official act. However, you'll notice in this Mr. Fry's legislation, the removal has to be for an official act to be removed for a former president or vice president.
Not for the president.
No, not for the current president, but for a former president. In other words, the discussion about what President Trump wanted removed during his campaign. Under this, it doesn't change the removal during that period in which he was a former president.
He would have, under this bill, as a former president, the local prosecution would have been removable. Under current law, it is not removable, nor should it be. A violation of state law should be prosecuted at the state level.
I think we just disagree on that. Who else seeks recognition? You've already seen.
I think I've already spoken.
Yep. Mr. Johnson?
Thank you. I yield to the gentleman from New York.
Thank you to the gentleman from Georgia. Mr. Issa, the Constitution applies to state courts as well as federal courts. So the Supreme Court's opinion applies as to official acts in state court just as it would in federal court. So I don't understand what your concern is about the application of the Constitution when that also applies to state court. And I would just say, Mr. Issa, in response to the quotes that you read, saying that I sued Donald Trump previously is not saying that I am going to indict him. And in fact, the investigation that was currently, that was at the time alive, was not the charge that was ultimately brought. In fact, Mr. Bragg refused to bring the criminal case that was under investigation. The line prosecutor who was investigating that case resigned in protest over the fact that Mr. Bragg did not charge President Trump with that investigation. So those quotes that you're talking about in the ongoing investigation that is referenced there was ultimately not brought by Mr. Bragg. So you can have complaints about what the actual charges were, and I think there are reasonable arguments to debate about the discretion, but it certainly was found by a jury to be a conviction. The president will have his appellate rights. He may appeal it, and if your allegations about converting a misdemeanor into a felony and statute of limitations and all that stuff are true, then a court would agree with you. But we already have the proper system to be able to deal with that. And so I think on both scores, you're missing the mark here. Again, if you want to go back just to say presidents and vice presidents should also, 1442 should also apply, let's discuss that. But that's not what this bill does.
Would the gentleman, yep. Oh, go ahead.
Okay.
Yield to the gentleman from New
I just
York.
wanted to pursue two other critical points of textual meaning. The good chairman suggested that when it comes to a former president or vice president, that would apply only to public acts and not private acts. There's nothing in the language of the bill to suggest that. On the contrary, it says a former president or vice president for or relating to any act while in office. And if that is to mean any public act, then there should be an amendment to that effect. But right now, it would apply to an assault, a rape.
Would the gentleman yield?
Yes, I will.
If you look at page 5.
I'll yield to the gentleman
line
from New
10,
York.
It says, no court may define or limit the scope of the duties of an official of the executive office of the president. So
And that's where I'm going right now. Thank you, Mr. Nadler. That's the other point that's so critical. And I was hoping that, Mr. Fry is back. Mr. Fry, could you, if you would yield just for a quick question, what was your intention when you drafted that language on page 5 on prohibition on limitation of scope? No court may define or limit the scope of the duties of an official of the executive office of the president. I have some questions about that.
I'm sorry, re-ask that again. I'm trying to find the
Wait,
page you're referencing.
if you go to page 5, D, prohibition on limitation of scope, no court may define or limit the scope of the duties of an official of the executive office of the president. But just while you catch up here, look, here's what I'm concerned about. If you read the court's decision in Trump versus United States, the way it's structured is this, that there are core functions of the president where the president is automatically, absolutely immune from criminal prosecution, like the exercise of the pardon power. Then outside of that, the powers of the president are described as official acts that might not be core functions. And there, he's presumptively immune, and it becomes a balancing operation to look at the public interest versus the president's interest. But outside of that, it's non-official private acts, presumably things like rape, sexual assault, murder, theft, fraud, where the president is treated like everybody else in that third tier. But here it says no court, that would presumably include the Supreme Court, may define or limit the scope of the duties of an official of the executive office of the president. So I just want to know, does that obliterate that tripartite taxonomy that we get from Trump versus United States? And does the president himself constitute an official of the executive office of the president?
Look, I think at the end of the day, state courts should not be defining what an official act of a federal official or former federal official should be.
But this says no court, so you would amend that to say no state court.
State courts. No. But state courts, where we are at with these cases that you guys are referencing, is that state courts were deciding what this is. And
No, I know, but I'm just asking about the language of your bill. When you say no court, do you there want to say no state court? Because we can amend it to say that. But right now, this would say no court, including the Supreme Court, can limit the definition of the duties of the president. And that would seem to overturn that tripartite analysis coming from, okay, well.
All right, gentleman yields back. Who seeks
Mr. Chairman.
recognition? Gentleman from Kentucky.
I move to strike the last word.
Gentleman is recognized.
I'd like to yield time to Mr. Fry.
Gentleman is recognized.
I thank the gentleman for yielding, and I think it was discussed earlier that this was not about politics and that people campaigning for district attorneys were not campaigning on going after the former president, now current president, but that, of course, is belied by the evidence, and I think we have a video to show just that.
Whoever has this job, are they going to convict Donald Trump?
Look, that is the number one issue. I'm the candidate in the race who has the experience with Donald Trump. We sued the Trump administration over 100 times. I sued Trump over 100 times and brought a case against the Trump Foundation and held him accountable. Holding Trump accountable for the Trump Foundation.
From exposing illegal behavior by the Trump Foundation.
I do have a lot of experience with the former president. I led the New York State Attorney General's work and investigation and successful litigation against him and his family for their misconduct with the Trump Foundation. And also we had a number of litigations, more than 100 involving the Trump administration. I led the team that held Trump and his children accountable for their misconduct with the Trump Foundation. I oversaw the work which sued his administration more than 100 times. I led the Attorney General's work on the Trump Foundation case where we held Trump and his family accountable. When I was at the Attorney General's office, I led our work on the Trump Foundation matter. I also led the team that did the Trump Foundation case And I've seen him up front and seen the lawlessness that he can do. Started out as a civil rights lawyer, then became a federal prosecutor, ultimately was the #2 lawyer in the New York State Attorney General's office, leading the charge against the racist policies of the Trump administration. I believe we have to hold him accountable. I've litigated with him, and so I'm prepared to go where the facts take me once I see them and hold him accountable. Being a rich, old white man has allowed you to evade accountability in Manhattan. That includes Trump and his children, right? We held him accountable in the Trump Foundation case. My office did the Trump University case. So I've seen a pattern of lawlessness over 20 years. And so I'm inclined to believe all I see in the public domain and know that and believe that there's a path forward there to make a case.
So I think we go back to the basic premise of the bill, is that you have a prosecutor in New York. You're not worried about crime in New York, Manhattan. He is worried about going after the former president of the United States. Why? Because it earns him political points in a jurisdiction that did not vote for Donald Trump. And so they elected this guy to go after him, despite the fact that there are other crimes that you could be going after, but resources are dedicated. And so to sit here today and say that this has not been about politics, this is about fairness in the system, it's total BS to believe that that is actually the case, because he said it 1,000,000 times on television. He campaigned on it, and that is the purpose. One of the huge purposes of this bill is to remove that from a fairness perspective, that a jury in a federal system, that a different system that is not rigged in a state court can go and have a fair trial. The presumption of innocence is on a criminal defendant, and if we do this for ambassadors, if we do this for sitting presidents right now, why would we not extend that to somebody when they are targeting a former president or vice president?
Will the gentleman yield
for political
for a
points?
question?
And with that, no, I yield back
Gentleman declines to yield.
to the chair, or to the gentleman from Kentucky.
Gentleman yields back. Gentleman from Kentucky.
Will the gentleman from Kentucky yield?
I yield back to the chairman.
All right, gentleman yields back.
Very unfriendly over there.
The gentleman from New York.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, what we saw was Alvin Bragg talking about how he prosecuted, as an official, I think in the AG's office, Attorney General, he prosecuted the Trump Foundation. Well, the Trump Foundation, let me read you a headline from December 10th, 2019. Donald J. Trump pays court-ordered $2 million for illegally using Trump Foundation funds. The courts also found that Trump University was a fraud. The court also found, a separate court also found that Donald Trump sexually abused E. Jean Carroll, and the judge said that's the technical term, but most people would consider that rape. So the fact that Alvin Bragg brought up some of these prior actions which he had been involved in and which Trump had been involved in when he was a private citizen shows nothing other than that Alvin Bragg was a proper prosecutor. And remember what he said on that video. He said, "I'm prepared to go where the facts take me." That's what a good prosecutor should do. And that's what Alvin Bragg did. And the facts took him to a hush-money prosecution in which the former president was found guilty on 34 counts. And most of that was done when he was not president. The only reason that this bill comprehends that he did anything while president is that some of the hush-money checks were written while he was president after the fraudulent scheme had basically been completed. This shows nothing but that Alvin Bragg is a proper prosecutor, took the facts where he wanted, took the cases where the facts indicated, and in fact, he was very reluctant to prosecute Trump. His predecessor, Cy Vance, had initiated that. He had stopped it and then decided a year later that the facts warranted reopening the case. And I'll yield to Mr. Cohen.
Thank you. You yield for question?
Yes.
He said something that he he prosecuted or investigated Trump and the Trump Family Foundation. Can you refresh my recollection about what the Trump Family Foundation did and what happened to them?
Well, they were found guilty. They were forced to pay $2 million. I don't remember exactly what they did, but they committed a fraud for which they had to pay $2 million.
Was that,
Gentleman will yield.
was that the foundation that bought pictures of Donald Trump and they kept them in the Trump family and used the foundation funds?
Yes.
Was it the same foundation that maybe gave a contribution to Bondi in Florida, $25,000?
I don't know.
Yield to Mr. Goldman.
I'll yield to the gentleman. I'll yield to the other gentleman from New York.
Thank you. Yes, you are correct. The board members of that charitable foundation were denied from ever being officers for a charitable foundation in New York again. And that was a previous case. That is a fact that I guess Mr. Bragg was involved in that case. And I think what undermines this whole argument of politicization is what I mentioned before. I don't know if Mr. Fry was here, but the investigation that was ongoing that he referenced, I've seen the public reporting, and based on that, I will follow the facts and I will hold him accountable. He followed the facts and declined to charge that case. If he was so intent on going after and getting Donald Trump, why would he overrule the recommendation of a very experienced prosecutor who came into his office solely to investigate that case, spent over a year investigating the case, recommended so strongly to charge the case that he wrote a whole book about it afterwards, after he resigned? I just don't understand how you can say that that was political when what he did is exactly what he said he was going to do and follow the facts, and he declined to charge the case. So stop making stuff up to suit your narrative. I yield back.
And I yield back.
Gentleman yields back.
Mr. Chairman,
Does anyone else seek recognition? Gentleman from Georgia.
I have a unanimous consent request for an article out of PolitiFact, which is entitled, "Here's What Manhattan District Attorney Alvin Bragg Said About Donald Trump During His DA Campaign," which was that he would continue his predecessor's investigation and hold Trump accountable by the facts where they go.
Without objection. Does anyone else seek recognition? The gentleman from Maryland.
Mr. Chairman, thank you. I've got an amendment at the desk.
Clerk will report the amendment. Gentleman from California reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 1789 offered by Mr. Raskin, page 5, line 11.
Without objection, the amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Mr. Chairman, thank you. This follows up on the colloquy that I had with the good gentleman from South Carolina. I think it saves at least part of the constitutionality of the bill. It says that no state court may define the scope of the duties of an official of the executive office of the president. Without that qualifying adjective, Mr. Chairman, I'm afraid that it renders the whole bill totally unconstitutional, because it's saying that the Supreme Court itself cannot define the scope of the duties of someone in the office of the president. And of course, that's what Trump versus United States did in assigning, absolute categorical presidential immunity to the president, acting within the scope of the core functions of his office, presumptive immunity subject to a balancing test within the outer perimeter of official acts of the office, and then extending no immunity at all when it comes to private acts. But this provision would, I think, whether deliberately or inadvertently, destroy that three-part analysis and say the Supreme Court can't define the scope of the duties of the president or anybody else in the president's office, as the gentleman said. So I think to salvage the constitutionality of it, we need to say no state court can do that, because under the Supremacy Clause in Article 6, the Constitution and the laws adopted in pursuance thereof are the supreme law of the land. And as the Supreme Court put it in Marbury versus Madison, it's emphatically the province and the duty of the Supreme Court, of the Judiciary Department, to say what the law is. And so this is an attack not just on Trump versus the United States, but on Marbury versus Madison. So with that, I would submit it to the wisdom of the committee, Mr. Chairman.
I'm recognizing myself. I know that this is well-meaning, but I must reluctantly oppose it because essentially by inserting this, what's happening is it implies that the federal court can in fact determine orders of the president to his staff and others would in fact be definable by the court rather than all of it flowing back to the same standard as the president. The president's use of people, whether confirmed or unconfirmed, but his use of people in his official acts are an extension of him, as we can imagine. We would certainly know that if he asked an attorney general to do it, we understand that.
Would the gentleman yield?
Just a moment. But if he asked his chief of staff to do it or somebody else that is not confirmed, this would neuter that. So for that reason, in its current form, I cannot support it, and I would yield to the gentleman from New York.
Mr. Chairman, if the President of the United States robbed a bank or committed murder or any other crime, under this bill, no court, the way it's written, no court can define the scope of the duty, so that can be held as official action if he says so, because no court may define what the official acts, what the duties are.
Reclaiming my time, under Article 2, those are not, murder is not within his official duties, robbing a bank is not within.
But if
So the court would still, and a gentleman's point is good, but the court would still, we're not stripping the court of its ability to interpret Article 2.
With all due respect, the language of this provision, D, does exactly that. It strips every court, and that's why Mr. Raskin's amendment saying no state court may do it makes sense, because otherwise you're saying that no court may define a crime as not part of the duties of the president, for which he is presumptively immune.
Yeah, I appreciate the gentleman. This is, you know, you're right in one sense. If the president robbed a bank under this, it might get removed to federal court. If he did it in concert with his chief of staff, it might get removed to federal court. But it wouldn't change the fact that he still would be eligible to, under the standard of Article 2, he still would be dealing with bank robbery. So there is no dismissal. And I'm going to use my time briefly just to get things maybe back to where I'd hoped they would be and would continue to be. This legislation is not about the current President of the United States. This legislation is about past and future presidents, vice presidents, and I would hope that in the spirit of really looking at this, we would all put our shoe on the other foot for a moment and say, whether it's a past president that we've all served with in the case of those at the top of the dais or a future president, all we're really doing here is trying to fairly come up with a standard that will work going forward. The history of the last few years shows that we can tie up a current or former president in courts and run them all over the country, all over the state, to multiple states. And if it was done in 50 states or 20 states, it could be even more dilatory. What we're trying to do is simply do the same thing that we in Congress enjoy, which is not to have our official acts impeded, particularly during that tendency of our presidency.
Would the gentleman yield?
I will in just a second. For that purpose, I would ask that people consider for a moment substituting the name Biden, the name Harris, the name Obama, or the name Bill Clinton, and ask if this were in place, and we were using this for other presidents and vice presidents, would it really be that unfair, or is it a standard that we, over the long run, would be better for our republic? The gentleman from New York.
Yeah, I would simply point out that under the Supreme Court decision in Trump versus U.S., the current president is immune from anything. But a former president ought to be subject to the law like anybody else. And if he has done things that subject him to prosecution, he ought to be prosecuted.
And I couldn't agree with the gentleman more that that we want there still to be a day in court. This bill does seek to limit it to make it appropriate for his official acts while he was in office, or she, a former vice president or president, to be held in federal court. And that's all we're really trying to do. With that, my time has expired. Who else seeks recognition? Gentlelady is recognized for 5 minutes.
Thank you, Mr. Chair. I yield to the ranking member.
I thank the very distinguished gentlelady from Vermont. I think we're getting somewhere now, Mr. Chairman, and so let's take the personalities out of it completely, all right? So forget about Biden, Trump, everybody. Let's just talk about what the law should be in the United States of America. So let's recapture Mr. Nadler's bank robbery hypothetical, okay? So a president robs a bank in the state of California. We'll go to your home state, okay. And he's prosecuted. Now, under the language of this bill, he can go in, if you look at page 2, in section 5 here, he can go in and say, one, that this act took place while I was in office, so I should be able to remove to federal court, one. And two, I've got a second reason, it's going to interfere with, hinder, burden, or delay the execution of my duties. So, if this law is constitutional, and I don't think it is, but assume it was constitutional, he gets into federal court. Now in federal court, he moves from the removal provision to the dismissal provision. And what happens there? We'll go to page 5 of the gentleman's bill, where it says dismissal, okay? In any action subject to removal, such case shall be dismissed unless rebutted by clear and convincing evidence establishing that the continued pendency of the state claim or charge would not in any way interfere, hinder, burden, or delay the execution of the duties of the president or vice president. And this is also a former president or vice president, okay? So, but the president or vice president obviously wins on that. Who could say that having a criminal bank robbery prosecution, which has now been removed from state court to federal court, would not interfere with the execution of that president's duties? And so this is a way to completely obliterate the existence of the crime and the criminal prosecution and the state criminal jurisdiction, and here even federal criminal jurisdiction. And then if somebody says, well, wait a second, that's not fair, this had nothing to do with the president actually executing the duties of office. This is something that under Trump versus Anderson was in that, or rather in U.S. versus Trump, was in that third category. It was not, it was neither in the core functions of office, nor was it another official act outside of the core functions, but it was something completely private. The president, woke up in the middle of the night and went and robbed a bank or committed, wire fraud or whatever it was. And now, if you look at the provision right above dismissal, it says, no court may define or limit the scope of the duties of an official of the office of the president. In other words, it's not up to the court to say that was a private act. That was a criminal act. In other words, what the federal law was following the U.S. versus Trump case has now been vanquished. And what do you know? It's a get-out-of-jail-free card for a president to commit any crimes at the state level. So I am totally with...
The gentlelady yield for 1 second?
As long as you call me the gentleman, that's cool with me. So,
I said gentlelady because she has the time.
The gentlelady.
Oh, that gentlelady, okay. I will yield back to the gentlelady, yes.
I just wanted to point out that everything Mr. Raskin says is applicable not only to current, but to former presidents. So a former president who committed bank robbery would still have his case removed to federal court and would not be subject to the laws of the state for no good reason at all. And I yield back.
But all I would say, Mr. Chairman, like with complete sincerity and honesty, is like, let's pull this bill. It's an absolute monstrosity. I think it's an embarrassment for any member of Congress to be voting for this. And I will yield back to the gentlelady.
And I now, oh, you yield to me? Okay. You know, look, I certainly think that we can go back and forth on some nuances of the meaning. And unfortunately, we are playing, in my opinion, a little fast and loose with the difference between current and former, because the intent of the bill and the words as I read them do limit the benefit to a former president or vice president in consideration, because a former vice president does not have the standing to say it's interfering with his current official duties. And using the example of a certain former president, he did not prevail on the question of his campaign. Having said that, I believe that as we go through this, that if we go back to putting the hat back on and saying, is this good going forward, or should we strip away from the federal judges and ourselves the current and similar immunity that is in the underlying statute? And I thank the gentlelady from Vermont. Who else seeks recognition? The gentlelady from Wyoming.
Thank you. Article 2 of the Constitution states that the executive power shall be vested in a president of the United States of America. In other words, it is the president that defines the executive branch. When you read this language, it says that no court may take over that role. No court may define or limit the scope of the duties of an official of the executive office of the president, the people who work in the executive office. I think that what your amendment does is a violation of separation of powers, and it's a violation of Article 2 of the Constitution.
The gentlelady yield?
Yes, I will.
It's always good when the constitutionalist specialist comes in. It helps us all. So what you're saying is that the bill codifies Article 2 for purposes of the court being reminded and instructed of their limitations, and the amendment would undo that.
That's exactly right, because then it would imply that a federal court could in fact define or limit the scope of the duties of those individuals who work within the executive office of the president, and that is not a federal court's role. That is for, under Article 2, Section 1 of the Constitution, that power is vested in a president of the United States of America.
Could the gentlelady further yield for another question?
Yes.
Your understanding is, with the current president, or the last one, or the next one, if we don't do something like this, realistically, the chief executive, president, would continue to have to answer a myriad of claims in up to not just 50 states, but multiple places in 50 states. And if that tactic was used, even more so than it may have been used in the past, that you would have a president having to use non-official funds to answer a series of cases alleged not to be that way. Is that true?
That's the way that I read this, and I think that it's very clear, especially starting in 2017 when President Trump was sworn in the first time, that the courts have been used for nefarious purposes on a variety of issues. In fact, yesterday we had a hearing in our constitutional subcommittee about lawfare and how lawfare had been weaponized against President Trump, both while he was president as well as after his presidency. So again, I guess that I'm very skeptical of the idea that people are not willing to use lawfare to go after a current or former president. We've seen it over the last 9 years in many different instances. But the president is the one who gets to define the limit and scope of the duties of the personnel within his office. That is very clear from Article 2 of the Constitution.
Will the gentlelady yield for a question on that?
Yes.
But I assume you've read the Chief Justice's opinion in Trump versus United States. And if so, are you saying that this decision was wrongly decided in distinguishing between core functions of the president, where his discretion is indeed absolute, as you suggest, the official acts that are not within his core functions, where Chief Justice Roberts says that's subject to a balancing test, and then private and unofficial acts where he doesn't get to define it all, that's up to the court.
That's not, we're not talking about immunity. We're talking about something entirely different.
Well,
It's
what-
about who gets to define, who defines, and I think.
But that's
that when you
precisely
read-
what they did with respect to immunity.
It's the gentlelady's time.
Okay.
When you read the decision, they did not strip the president of the ability to define or limit the scope.
Yes, they did.
The duties of the personnel within.
They
his
said if it's
office.
private and unofficial, the court will know it. And that's exactly what this is about. If you rob a bank, you can't say that's part of my duties because I'm trying to reform the CFPB.
And that's not what he's saying. When you're defining or limiting the scope of the duties of an official within the executive branch within the official of the executive office of the president, all we're trying to do is prevent the violation of the separation of powers, as I've indicated. And I
No, you're
disagree
trying to
with you.
strip the court of substantive jurisdiction over the president's powers, and you can't do that. It's emphatically the province and the duty of the judicial department to say what the law is,
That
including
isn't
over
what
the
this
president.
says. That is not what this provision says.
Well, if it doesn't, what does it say then? What does it mean to say no court may define or limit the scope of the duties of an official of the executive office of the
The
president?
executive office, the president has the ability to define the scope of the individuals that work within, the scope and the duties of the individuals that work in his office.
So that could
is
include
not for-
criminal
That is
actions.
not for a state court or a federal court to define.
So that could include criminal actions.
That is absolutely an absurdity to even
Well,
make
then
that
you're not reading
allegation.
Chief Justice Roberts' opinion. That's what it's all about. How do we constrain executive power? And you're saying you can't constrain executive power because the executive power is vested in the president. But that's a
executive branch.
tautology. But that's just a
is.
tautology. The legislative power is vested in Congress, but that doesn't mean we can do whatever we want. We can't violate people's rights.
The gentlelady's time has expired. Who else seeks recognition? Seeing none, the question is on the amendment to the amendment in the nature of a substitute. Oh, I'm sorry. By the gentleman from Maryland. All those in favor say aye.
Aye.
All those opposed, no. In the opinion of the chair, the noes have it. The noes have it. The amendment is not
We have a
agreed to.
recorded vote on it, Mr.
Recorded vote being ordered. The clerk will call the roll.
Mr. Jordan? Mr. Issa?
No.
Mr. Issa votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Fry, you're not recorded. Mr. Fry votes no. Ms. Jayapal? Ms. Jayapal votes aye.
The clerk will report.
Mr. Chairman, there are 11 ayes and 14 noes.
The amendment is not agreed to. For what purpose does the gentleman from New York seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report. Gentleman reserves a point of order. The clerk-
Amendment to the amendment in the nature of a substitute to H.R. 1789.
Without objection, the amendment shall be considered as read, and the gentleman from New York is recognized to explain his amendment.
Thank you, Mr. Chairman. Mr. Chairman, I am offering a very simple amendment, one that should not be controversial. It would exempt from this bill a crime for which we arrest, imprison, and even deport people every single day: fraud. The American people deserve to understand what this bill from the majority is really intended to do. It is a blatant, shameless attempt to protect a convicted felon, Donald Trump, who is indicted in over 90 criminal charges across multiple courts. Last year, in my home state of New York, the nation watched as Trump became the first former president to be convicted of felony crimes. In the end, he was convicted on a whopping 34 felony counts related to a hush money scheme to cover up an affair with an adult film star and illegally influence the 2016 election. I believe we have a video from the day he was convicted.
We've got a verdict. Ari Melber.
We are looking at count 1, guilty. Count 2, guilty. Count 3, guilty. Count 4, guilty. Count 5, guilty. Those are the first 5 counts coming out of this jury, finding Donald J. Trump guilty on the first 5 felony counts. Reading the rest as we are getting it from our court reporters.
Starting with count 6.
Count 6, guilty. Count 7, guilty. Count 8, guilty. And you'll see on the screen we're tracking ahead. Count 9, guilty. Count 10, guilty. Count 11, guilty. Count 12, guilty. Count 13, guilty. Count 14, guilty. Count 16, guilty. Count 17, guilty. Count 18, guilty. Count 19, guilty. Count 20, guilty. Count 21, guilty. Count 22, guilty. Count 23, guilty. Count 24, guilty. Count 25, guilty. Count 26, guilty. Count 27, we're seeing that on screen, guilty. Count 28, guilty. Those are the first 28 felony counts here as read by the jury. Count 29, guilty. Count 30, guilty. Count 31, guilty. Count 32, guilty. Count 33 and 34, guilty. That is Donald J. Trump, defendant in New York versus Donald Trump, found guilty on all 34 felony counts. That is the verdict here in this case.
I believe, as you can see, in the interest of time, we sped up the tape to get through all 34 guilty verdicts quickly. However, those 34 felony convictions aren't the only legal challenges Trump faces in New York. Last year, New York Attorney General Tish James caught Donald Trump red-handed in one of the largest fraud schemes in state history. He was found liable for civil fraud and ordered to pay over $350 million, an amount that with interest now exceeds $500 million. What was the nature of this fraud? Years of deceit, scheming to inflate his wealth on financial statements, misleading banks and insurers, and manipulating accounts to maintain the illusion of being wealthier than he was. This was not merely a clerical error or misunderstanding. It was a calculated, deliberate fraud. Currently, Trump is appealing that case in state court. However, I imagine he would love for this bill to become law so he could remove that case from the New York courts, transfer it to federal court, and according to the provisions of this bill, seek to completely evade accountability. This is outrageous. Mr. Chairman, my Republican colleagues say they oppose a two-tiered justice system. But what do they call this situation? Why should a billionaire who holds the highest office in the land be allowed to evade accountability for crimes that would likely lead to imprisonment for any ordinary person? No one, whether it's the president or anyone else, should escape consequences for intentionally and immorally deceiving New Yorkers out of hundreds of millions of dollars. Republicans also claim to support states' rights. However, this bill would take away the ability of states to hold accountable those who attack and defraud their citizens. New York has the ability and the right to enforce New York crimes in New York courts. This bill should also be unnecessary. We have never had this issue come up for any other president in our more than 230-year history. Only now, because we have a convicted felon in the White House, do our Republican friends feel they need to change the law to ensure that Donald Trump will never again be held accountable in a court of law. Pathetic. I encourage my colleagues to vote against this underlying bill, but I hope they will at least adopt my amendment to ensure that states have the power to hold those accountable who attack and defraud their citizens. I yield back.
For what purpose does the gentleman from New Jersey seek recognition?
I'm going to make this simple, and
The gentleman is recognized for 5 minutes.
Thank you. We, had a very long meeting the last time on this committee. In fact, in our subcommittee hearing on oversight, we also had a very long meeting. So I'm going to do my best not to speak as much. It's hard to do, though. Let's just forget about the Trump thing and weigh the bill on its merits. And I would say to my friends on the other side, be careful what you wish for, because this is a theme we have in the subcommittee. If it happened to him, if it happens to a Republican, if it happens to a conservative, and when I say it, I mean weaponizing the judiciary, weaponizing the Department of Justice, it could happen to you as well. It could happen to any of us. Now, we all know that, when it comes to this civil case, because that was the last case that my friend from New York spoke about, that clearly Letitia James was less fulfilling her role, her legal role, and more a political role. Clearly, there has been some cooperation between the Department of Justice in many of these cases, and I won't go through them all, and actually what happened in some of these cities and counties. And clearly, it's so obvious that this really could happen to anyone, and that these charges were blown up. Supposedly he overrated the value of his properties, et cetera, his wealth. All the banks that were involved in all these transactions, to this day, will say they're more than willing. They would love to lend him money again. He paid his money back on time, when he was supposed to, the full amount, without any problems. Everybody knows, we're having the political argument here, but everybody I believe you should know that there is merit to this legislation, to Congressman Fry's bill. Everyone knows that we politicized the judiciary and the Department of Justice. And what I'm telling you is, life's a funny business. It's a cycle. And if it happened to him and it happened to us as Republicans, it could happen to you as Democrats. So let's clarify this and make sure that regardless of whomever is the President of the United States or the Vice President of the United States, that they are clearly able to function and do their job without fear.
Would the gentleman yield?
I will yield, yes.
Thank you. I would simply point out that regardless of the motives of Tish James, regardless of the motives of Alvin Bragg, which I think in both cases were fine, but regardless, juries found Donald Trump guilty in the financial fraud case and in the hush money case. And I will say that if any Democrat, former president, future president, non-president, is found guilty by a jury of his or her peers, they should pay the penalty. And Donald Trump is no different. Alvin Bragg, you may say, had bad motives. Tish James, you may say, had bad motives. I don't agree in either case. But separate juries, found Donald Trump guilty, and under our system of justice, that ought to be dispositive. I yield.
I'll reclaim my time. I understand your point, but the truth is, again, that this was a really difficult jury process there, jury selection, and that the Trump people had asked to have this hearing in another locale, to move the jurisdiction, and they should have. And I'm not saying to a Republican area, but to a neutral ground. There was nothing neutral about this ground. And we've gone through all this and we're not going to hash it out all again. But I'm telling you to really think about what I'm saying, to be careful. It was wrong what happened. It went from trying to get him through the legal system to trying even having secretaries of state pull his name off the ballot, which was clearly illegal and inappropriate as well. Folks on your side just didn't want him to run. Well, the way it works is he was nominated by the party to run a good election, fight hard, and see who wins. The way to stop a candidate from serving as President of the United States is not by misusing and weaponizing and politicizing the judicial system. So I ask you to think about it. I do not support this amendment, and I yield back my time.
The gentleman yields back. The gentlelady from Washington is recognized to strike the last word.
Thank you, Mr. Chairman. I think we have to be very careful when we start to question juries and the steps that lead to the jury system. I think all of this is extremely dangerous, and I think that right now,
Would you yield for 1 second, and I promise
let me
I'll-
get through my comments,
Okay.
and then I absolutely will. I think right now, House Republicans are doubling down on a very dangerous proposition, because this proposed bill codifies presidential immunity in 2 steps. It allows, first, any president to remove any civil or criminal case from state court to federal court related to, quote, any act while in office. And second, it establishes a presumption of immunity for any of the removed cases. And so the result is that not just Donald Trump, but any future president, and I would just turn it back to you and say, if you have a Democratic president, is this what you want? Any president is shielded, including Donald Trump, is shielded from civil or criminal liability for any violation of state law simply because he's president. We are not supposed to have kings in this country. And I want to take one of the arguments that Justice Sotomayor made during the Supreme Court discussion of presidential immunity. Imagine that President Trump, and you can substitute any Democratic and Republican name in here, but let's imagine that President Trump authorizes the military to assassinate Joe Biden, and that a local prosecutor brings a first-degree murder charge. Because the act happened, quote, while in office, Trump would be able to remove the criminal case to federal court. Then he would be able to assert immunity since the case was removable. And there would be no justice achieved. If that sounds extreme, it's because the bill is extreme. And I think when you ask us to apply it in a different situation, and I am going to try to give you a minute here, I think you have to think about, is this what you want? That's not where it ends. The bill actually even goes further than the Supreme Court did, because it expands immunity to all acts, including acts that have nothing to do with presidential duties. So here's another hypothetical example. Imagine that President Trump confiscates farmland to build a Trump hotel and golf course. Then a local prosecutor brings charges against Trump for larceny. And once again, because the act occurred, quote, while in office, Trump would be able to remove the state court case to federal court. And then when in federal court, he'd be able to assert immunity from criminal liability because the case was removable. I do think that one of the hallmarks of our democracy, if my colleagues on the other side agree with the principle of democracy, is that the president is not a king. The president is not a king, and yet it seems to me that my colleagues on the other side, intentioned or not, are doing everything in their power to make the president, not just this one, but any future one, a king. This bill, if enacted, would make him a king. So I'm going to yield to Mr. Van Drew, just so you can respond. Is this what you envision, that any president should be a king? In those examples, if I substituted Biden for Trump, and would you be fine with those things happening?
Thank you. I thank the gentlelady. I appreciate her viewpoint. Yes, I would be fine. I mean, federal court, inherently, there is nothing.
So Mr. Van Drew, so you are okay with the president having zero accountability? Republican president, Democratic president, zero accountability,
I'm not,
and being able to do anything they want, including murder, including appropriating farm. Our job is to take it to the hypothetical of the things that could happen. That's what we do when we pass legislation.
30 seconds. So, no, of course I wouldn't be all right. Nobody's saying that, and that would also, murder is a federal crime, can be a federal crime.
But he would have immunity according to this bill.
But we've never had this issue before, and the problem is that we now have prosecutors and attorneys general in various locations. And again, be careful what you wish for. Hypothetically, I'm going to be very open-minded here. It could happen where you had just the reverse situation. A very, very, very Republican state goes and sues a president or a vice president that's a Democrat. In fact, it well may have happened. And the other issue that I wanted to deal with real quickly is, cases are moved all the time. So what they believe.
Mr. Van Drew, I'm going to
neutral
reclaim my
ground.
time because that is part of the process. They either get moved or they don't get moved. The determination is made. You either believe in the justice system or you don't. And what my colleagues have been doing is undermining the justice system over and over again and not holding the president accountable, giving him a free rein, or her, potentially in the future in this country, a free rein to do anything they want, I don't think serves our justice system. I yield back, Mr. Chairman.
The gentlelady yields back. Who else seeks recognition? The gentleman from California is recognized to strike the last word.
Thank you, Mr. Chairman. This is the simple, awful truth about the Biden administration. For the first time in American history, a presidential administration targeted its chief rival for criminal prosecution, concocted the most flimsy criminal charges, turned the federal law enforcement machinery against him, and colluded with Democratic state law enforcement officials to do the same. This is the historical record. This has happened. And when we speak of threats to democracy, what greater threat can there be than one party trying to jail its leading political opponent? For the first time in our history, a presidential administration executed an armed raid on a former and future president's home. For the first time in our history, the leading candidate for president was gagged by a rogue judge in the middle of a campaign. For the first time in our history, the leading candidate for president was pulled off the campaign trail in the middle of that campaign and compelled to sit through a grotesque mockery of a trial. My friend from New York, who seems to revel in the sham conviction that experts across the political spectrum, from Alan Dershowitz to Jonathan Turley, have all denounced as a glaring miscarriage of justice, if that analysis is confirmed by the higher courts, my friend from New York is going to spend the rest of his life having his words thrown back at him. The American people already...
Would the gentleman yield?
No. The American people already sat as the largest jury in history in 2024, and they saw right through the Democrats' corrupt abuse of our justice system. According to at least one poll, Americans reported they viewed the greatest threat to democracy as coming from the Democrats. And after all, what greater threat can exist to a democracy than a political party that sets aside the results of primary elections it doesn't like, gags its opponents, uses the FBI to strike down speech it doesn't like, and tries to jail its opponent on specious charges. The Democrats obviously lack any facility for self-reflection or self-awareness, as President Trump tried to remind them last night. How did that work out for you? You know, Bobby Kennedy asked, has there ever been an instance in all of recorded history when the people trying to censor dissent turned out to be the good guys? The same question can be asked of those who try to jail their political opponents. So my Democratic colleagues might want to take a step back and consider how history will judge them in the years ahead when passions have cooled and the facts remain. You know, my father was a veteran of World War II, and when I was a child, the memories of that terrible epoch were still fresh, and he used to lecture us at the dinner table from time to time about midnight knocks on the door of political opponents, persecution of disfavored racial or political groups, suppression of speech, the perversion of the justice system, and the terrifying place where all of that leads. But every one of my father's lectures ended with these words: "Don't worry, that can't happen here because of our Constitution." Well, we've just lived through an era when that did start to happen. Our Constitution held this time. The people reasserted themselves. And it's now our responsibility to strengthen our laws to prevent us from ever starting down this dark road again. The absurd hypotheticals we hear from the Democrats give us some insight into their delusions involving Donald Trump. I'd simply remind them that Donald Trump never crossed the lines of civility and democracy that the Democrats trampled over these last 4 years. In the aftermath of this woke fever dream that we're emerging from, it's our responsibility to enact laws that make it impossible for our colleagues to ever again use the most fearsome powers of government to intimidate and obstruct and censor their political opponents. I yield back.
I move to strike.
Gentleman yields back. The gentleman from New York is recognized.
Thank you. My colleague who just spoke left one other first out of his list of firsts, which is that for the first time in history, a president tried to overthrow a lawful election, tried to incite a mob to invade the Capitol to stop the proper counting of electoral votes. That a president, for the first time in history, schemed and pressured officials all around the country to make up and fraudulently say that he won the election. That's also the first time in history. And while I know that my Republican colleagues have so much difficulty imagining the possibility that a Department of Justice could actually be non-political, because this Department of Justice and Donald Trump's first Department of Justice were so nakedly and brazenly political. But the point of having a special counsel is to remove the investigation from the supervision of the appointed Attorney General. Now, you may not like the special counsel regulations. You didn't like the independent counsel statute, which Republicans ultimately opposed. But the reality is that the Biden Justice Department also appointed a Republican special counsel to investigate Joe Biden for his possession and retention of classified documents. Now, I've heard many of my Republican colleagues create this false equivalency between the two because, of course, when President Biden found the documents, he immediately called the FBI to turn them over and sat for a 5-hour interview. When Donald Trump was informed that he had 15 boxes or more of classified documents, he hid them, he lied about whether he had them, he concealed them. He then lied again to the FBI about whether he had them pursuant to a subpoena. And ultimately, the FBI learned that he was obstructing their investigation and he refused to turn over the classified documents. That is not the same as Joe Biden. But a special counsel is independent from the Attorney General. And other than your accusation, constant accusation, that the special counsel was appointed by the Biden Department of Justice immediately after Donald Trump announced that he was running for president, you have actually no evidence, no support for the notion that this was political, other than the fact that Donald Trump was a candidate for president, which, of course, he became so that he could use that defense. And if you look at the January 6th indictment and prosecution, as well as the others around the country, including guilty pleas by attorneys for Donald Trump who were trying to help him overturn the election. And if you look at the Mar-a-Lago classified documents case and that search warrant and that indictment, it is powerful and overwhelming independent evidence provided not by Merrick Garland, not by the Biden DOJ, not by the special counsel, by witnesses, by emails, by texts, by actual evidence. So if you're going to come and continue to make the baseless allegation that the Biden Department of Justice was politicized, then why don't you have some actual evidence to support those allegations? You guys had no problem interfering in the Hunter Biden case. You didn't like the plea agreement that he got. So members of Congress, the political legislative branch, wrote an amicus brief to a judge to object to a plea agreement. This was Biden's Department of Justice that was prosecuting his son. It's absurd. Just stop saying it. It does not add up that simply because you say it means it's true. Give me some evidence other than the fact that Donald Trump was a candidate for president, which he created himself to provide that defense. And I apologize to Mr. Nadler. I ran over time, but I yield back.
Gentleman yields back. I would just point out the court found that the case against Hunter Biden had problems in the agreement that they were trying to enter into. The chair
Yes, so that he wouldn't be prosecuted by Donald Trump.
recognize the gentleman from Arizona.
Thank you, Mr. Chairman. What a convenient thing is selective memory. It's a convenient thing. We just heard that the first time this happened, was all Donald Trump. But actually, the very first time in history, or at least in the last 50 years, that a presidential candidate attempted to thwart counting of electoral votes was in 2000 when Democrats in Congress attempted to decertify President Bush's victory over Gore. Then, in 2016, Democrats again attempted to decertify. That was Trump's victory over Hillary Clinton. And it wasn't the first time that a presidential candidate claimed that her electoral defeat was rigged. Hillary Clinton still thinks she won the 2016 election. She still thinks there was some kind of Russian interference that has been totally debunked. Hillary Clinton is she's the poster child for claiming that Donald Trump's presidency was illegitimate. Yeah, so it is really a convenient thing, selective memory. You get to pick and choose what you want, which allows for forgiveness for your distortion of facts, which allows you to ramble on and create the narrative that you want to create. And my colleagues have the most remarkable thing. They have a collective selective memory. And they choose to ignore the realities. I support the underlying bill and oppose the amendment. I'm going to yield back to the chairman.
The gentleman is back. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I yield to the gentleman from New York.
I thank the gentleman. I want to point out a few things. After the 2000 election, after the 2016 election, some Democratic members of Congress objected to certifying the results. No Democratic senator joined them, so it was dismissed. But unlike 2021, no Democrat provoked a mob to attack Congress, to cause the deaths of police officers in order to stop the counting of the electoral votes. It is very different to object in the House, which is your right as a member, than to provoke an armed riot, number one. Number two, we have heard from our Republican colleagues today about the armed raid on President Trump's Mar-a-Lago estate. It wasn't an armed raid. That was the FBI executing a court warrant. And why was it necessary to get a warrant? Because Donald Trump refused to surrender classified documents. So they went to court and they got a search warrant, and the FBI executed the search warrant. Characterizing it as an armed raid doesn't change the facts. We're told that the Justice Department under Biden was weaponized against Trump, against Republicans generally perhaps. But let's take a look at that. Yes, a special prosecutor was appointed to investigate the riot, investigate Mr. Trump's role in the riot that attempted to stop the counting of electoral votes, and to investigate the the unauthorized retention of classified documents. A special prosecutor was also appointed to investigate President Biden's retention of secret documents, the difference being that President Biden immediately turned them over, and the special prosecutor therefore said, no problem. The special prosecutor, the Justice Department, I should say, was so weaponized against Republicans and for Democrats that it prosecuted the son of President Biden. It was so weaponized that it prosecuted a very prominent Democratic U.S. Senator, Robert Menendez. Mr. Chairman, this is not a weaponized Justice Department. This is a Justice Department doing its job and bending over backwards to do its job properly. And
Would the gentleman yield?
I will.
Are you referring to the current Justice Department?
No, I am referring to the Justice Department under President Biden.
Gotcha, thank you.
The current Justice Department, I'm glad the gentleman raised the point, is systematically identifying all the FBI agents who worked on the January 6th prosecutions, many of them by assignment, not by choice, and firing them. This is, talk about weaponizing a Justice Department. And the new head of the FBI has an enemies list, which he published. So, and as Mr. Goldman said, there is no evidence whatsoever that the Justice Department under President Biden did anything wrong, that Alvin Bragg did anything wrong, that Tish James did anything wrong, other than the simple assertion by Republicans that they did with no evidence to back it up whatsoever. I yield back.
Gentleman yields back. Oh, excuse me, it's gentleman from Georgia's time, that's right. Gentleman from Georgia
Yield back.
yields back. The chair recognizes the gentleman from Florida.
Thank you, Mr. Chairman. So I'll play like a little social experiment with my colleagues in the room. There's only like 5 of them here, but that's okay. We're light on members too. So I want to play this game because I just want to make sure I understand the point and that we're going to apply it evenly. So how many of you believe, and raise your hands, I mean, let's just get you on the record. How many of you believe Mike Pence should not be prosecuted for not listening to Donald Trump on January 6th? Should not be prosecuted. He shouldn't be prosecuted because he didn't listen to the president on January 6th. Right? Anyone want to raise your hand? No? So maybe Mike Pence should be prosecuted? That's potential. Okay, we got one. We got one member willing to say Mike Pence should not be prosecuted for not listening to Donald Trump on January 6th. Let's do Joe Biden. How many of you, by a show of hands, think, based on this, the law you want to pass, Joe Biden should not be prosecuted for anything he did in the Oval Office? Remember his dereliction of duty at the border? He should not be prosecuted. Let's get you on the record that he shouldn't be prosecuted. Nobody, no Republican wants to wave his hand. So fair game, Joe Biden could be prosecuted. So again, this is not about policy that you actually believe in. It's about settling the scores of what happened to Donald Trump. First of all, this is not going to get 60 votes in the Senate anyway, so this piece of legislation is dead, okay? And you don't even want to apply it evenly. You don't even want to apply it, even Mike Pence, poor Mike Pence, could be prosecuted. And so, look, I'm not going to use all of my time because this is just a total waste of an exercise.
Gentleman yields back. The question occurs on the amendment offered by gentleman from New York. All those in favor say aye.
Aye.
All those opposed, no, no. In the opinion of the chairs, the noes, or opinion of the chair,
Mr.
the
Chairman,
noes
I
have it.
ask for a recorded vote.
And the gentleman from New York asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Fry votes no. Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgartner, Mr. Raskin,
Aye.
Mr. Raskin votes aye. Mr. Nadler, Mr. Nadler votes aye. Ms. Lofgren, Mr. Cohen, Mr. Johnson, Mr. Johnson votes aye. Mr. Swalwell, Mr. Liu, Ms. Jayapal, Ms. Jayapal votes aye. Mr. Correa, Ms. Scanlon, Mr. Neguse, Ms. McBath, Ms. Ross, Ms. Ross votes aye. Ms. Ballant votes aye. Mr. Garcia, Ms. Kamlager-Dove, Mr. Moskowitz, Mr. Moskowitz votes aye. Mr. Goldman, Ms. Crockett, Mr. Massey, you're not recorded. Mr. Massey votes nay. Mr. Issa votes nay. Mr. Kiley votes nay. Ms. Scanlon votes aye.
Clerk will report.
Mr. Chairman, there are 8 ayes and 11 noes.
The amendment is not agreed to. Who seeks recognition? Gentlelady from Vermont.
Thank you, Mr. Chair. I have an amendment at the desk.
Clerk will report. Gentleman from California reserves point of order.
Amendment to the amendment in the
Without
nature.
objection, the amendment will be considered as read. The gentlelady from Vermont is recognized to explain her amendment.
Thank you, Mr. Chair. My amendment is pretty straightforward. It would exempt crimes related to sexual assault from being removable from state court to federal court. As we've talked about all morning, this bill before us would essentially grant a president immunity for any crime, even at the state level, through allowing him to remove all state cases to federal court where they would be categorically dismissed, including sexual assault and abuse. No one should ever get a pass for sexual abuse. I think it's especially important that we exempt sexual assault from the list of crimes a president can get a carte blanche for, because obviously sexual abuse is not an essential part of the duties of a president of the United States. And frankly, if a president abuses, he is seen as the most powerful man in the country. And it's critical that he be held accountable by a jury of his peers. 1 in 5 American women face an attempted sexual abuse or rape over the course of their lifetimes. Over 80% of American women, and over 40% of American men face some kind of sexual assault or harassment in their life. So what message does it send to women and girls and any crime victim if we sit here and tell them, hey, we're here for you, we're tough on crime, we're gonna hold people accountable, we'll go after your attackers, unless, of course, they are federal officials. Then they should get a pass. This is a chilling message to send to young girls and women across this country. We know that our colleagues across the aisle spend a lot of time talking about tackling violent crime. But it has become clear to me that they only mean violent crime committed by some of individuals perpetrated against other individuals that they deem more important. We should be doing everything in our power to protect these potential victims and not create carve-outs for their powerful and well-connected abusers. Every single member in this room right now can show solidarity with victims of sexual assault by supporting this very straightforward and simple amendment. And telling women and girls across this country, and again, young boys and all the men who have also been sexually abused and harassed, that we see you, that we have your back, and we will do what we can to protect you no matter how powerful your abuser is. We can do this right now. This is straightforward. It is not complicated. You know, and I often think about what is my role in this committee? Because I am not an attorney, but it was important that we have voices in this room that are representing regular people back home that want to make sense of what we're doing or not doing. And they don't understand why something so straightforward like this, we can't even get agreement on. No man should be above the law. And when we're talking about sexual abuse and harassment, something that touches so many women in this country, so many families, so many communities that are shattered by this, it is unconscionable that we would imagine for a moment that it is right to essentially give a free pass to any elected official, and of course, a president or a vice president. We have a responsibility in this room to give voice to those Americans who can't be in this room, who don't get to sit in these seats, who want to understand that we actually have their best interests in mind. So I urge my colleagues on both sides of the aisle to support this amendment. It makes sense, it is the right thing to do, and I see no reason why anyone would stand in opposition to this amendment. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Move to strike the last word.
Gentleman is recognized.
Thank you. So I think that the previous speaker kind of gave the whole show away because her reference is always to the masculine and never to a woman potential president or vice president. It's never reference to a woman being a perpetrator of a sexual offense. And I find myself also thinking as I listened to her, I couldn't help but think of Bill Clinton and the allegations made against Bill Clinton.
100%.
And then I'm also kind of baffled by all of the proposed amendments that we've seen, because the way I read the bill, and maybe I'm just reading it all wrong, is I wonder, in the federal court, do you have to get an information? Have an indictment? Have some kind of long-form charging instrument instead? Do you then have a preliminary hearing in some cases if you're not having an indictment? In other words, do you present to a judge? Do you not have a prosecutor who's going to present to a judge? Do you not then have the same burden of proof and the same standards of proof in the federal courts? I mean, it's the Democrats who've been telling us how wonderful the federal courts are for ages. And I find myself just kind of baffled by the whole thing, like you just don't trust the federal courts that you've been lauding all this time. I'm kind of baffled by that. I'm kind of confused by that. But in reality, if you read the bill, which I just read it again because I thought maybe I'm just absolutely, totally baffled by this thing, you still have the same burdens of proof, same due process issues that you're going to have at the state courts. So it seems to me that really what you want to do is undermine the very purpose of the bill and continue to allow vitriolic, specious, without substance state prosecutions, which then actually does what we exactly saw against President Trump, and that's forum shopping at the state level. That's what you saw. That's what happened. And so with respect, I'm trying to understand the gentlelady's amendment, but as I review this, it looks to me and seems to me that this amendment is part and parcel of all the other amendments that are really actually trying to create some kind of political statement as opposed to actually solving issues. And that's kind of like what I saw on the floor of the House last night. I mean, I love the little popsicle sticks with the little construction paper signs. Those are pretty special.
Trying to spend less money.
And yeah, save on money. I appreciate you didn't want to be extravagant. And then I was grateful for the people. I was so grateful for the people who had their T-shirt on with their protest on it. They took off their outside coat. But what I most appreciated about that, when they turned, they were actually facing me because I was sitting there, but I was about 6, 7 rows behind them. When they left the floor, I was grateful because I was able to move up and get a better seat. And I really appreciate that. May be the only thing I think that we're seeing moving together, working together on. That's a crying shame. But I was grateful to do that. The more serious and egregious one, of course, was waving one's cane in kind of a wild manner at the president. But the reality is, when I'm looking at the results of polling of people who actually watched the speech last night, it kind of gets at this whole thing that we've got here. And that is this absolute disconnect and failure to understand why the American people rejected you and your policies in such rich abundance at the last election. And that I think I'm going to draw a response here, but that's really what we saw on display last night. Sophomoric, childish, not even sophomoric, more juvenile than that, attempts to disrupt the joint speech. Now I'll yield back. Well, I'm waiting for the...
Gentleman yields back. The gentleman from Maryland is recognized.
Thank you kindly, Mr. Chairman. Let me start with the digression to address my friend from Arizona. First of all, I'm delighted that we were able to show you what a nonviolent protest looks like, and I appreciate the fact that you praised people for bringing signs and popsicle sticks rather than steel pipes and Confederate battle flags and Trump flags to beat people up. And so that is indeed in the spirit of the First Amendment. I'm taken with your suggestion that this was a demonstration of why the people rejected us in such overwhelming numbers, and I keep hearing discussion of a mandate that's quite a mandate that's less than 50% of the vote and is the lowest popular vote victory in many decades. But in any event, congratulations to Mr. Trump for winning by a bit over 2 million votes. Joe Biden beat him by more than 7 million votes. And not only did you not accept the reality of that mandate, you didn't even accept the reality of his election. So that's the difference between the two parties here. We're willing to stand by the constitutional process, even when it doesn't go our way, which is what makes us constitutional patriots, I believe, that we don't say that we believe in the Constitution only when it goes in our own direction. Now, I want to rise in very strong support of the gentlelady from Vermont's amendment, and I want to salute her for introducing this amendment, which I do think everybody on the committee should support. Look, here's where the law is today. The president, the vice president can remove a state criminal prosecution from state court to federal court if there is a valid constitutional federal defense. If there's a federal defense, then you get out of state court and you go to federal court. That's not enough for some of our friends because they want it to be a categorical removal. So we're going to just nullify federalism. We're going to nullify the jurisdiction of the state courts and say you can get out automatically. When? Well, you can get out if the act took place while you were in office, not that it was an official act, not that it was in the core functions of your office. It can be a private act, it can be a personal act, but you just have to have been in office, then you can remove to federal court. And then you can get the entire thing dismissed unless you can prove that it would not interfere with or impede or impair in any way your performance of your office. Like, tell me that that is not conferring immunity from criminal prosecution. So the gentlelady from Vermont comes forward and says, look, can we all agree that at least when it comes to rape and sexual assault, that's got nothing to do with the execution of your official duties? That's not what presidents and vice presidents are supposed to do. I mean, this reminds me of, I once took a class on European history, and we learned about the droit du seigneur, which was the right of feudal lords and monarchs to have sex with any woman that they wanted. They could simply decide that, you know, that woman's for me on this night, even on their wedding night. The ruling was that you could exercise the droit du seigneur. Well, this says a president and vice president can basically engage in sexual assault. As we know, some presidents have engaged in adjudicated civil sexual abuse and been found guilty of it. They can do that as a president, as a former president, and then they can remove a state criminal prosecution to federal court, and they can get out of federal court by saying this is going to trouble them in their very busy lives. I mean, come on. This is a statement of second-class citizenship for women. And the gentlelady says, all right, you guys want to be able to, you know, say financial fraud is something that you should be able to get dismissed as a president or a former president, as a vice president or a former vice president. But she says, at least for raping and sexually assaulting women, or in answer to the good gentleman, yes, a man could be raped or sexually assaulted too. Anybody. I understand the gentlelady's amendment applies in either direction, so we don't need to be detained with that particular distraction. But the point is that if a woman is going to be raped or sexually assaulted, the state should have the power to prosecute, regardless of who the defendant is. Yes, even the President of the United States, because just because you're big and powerful and rich doesn't mean you can go and grab them wherever you want. I yield back.
Gentleman yields back. Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I classify this and file this under politics. And let me just say the things that sometimes people don't want to say. First of all, nobody wants a president or a vice president to engage in sexual assault. Let's all agree upon that. We realize that. We think it's wrong, whether it's a Democrat, whether it's a Republican. God help us, hopefully it doesn't happen. We all agree. But the question here is, again, let's talk about what's really happened in some locations. In some locales, we have state prosecutors. We have political prosecutors, political attorney generals, political DAs, a political legal system that can be and has been misused. And quite frankly, locally, when I say locally, I mean state, and even city or municipality, it can be misused more easily than it can be at the federal level. And it was misused last time, and I don't have time right now, but my good friend on the other side, Mr. Goldman, I'd be willing to show him for hours how, you know, the system, the Department of Justice, and the Judiciary at various locales was misused for politics. It was weaponized, and it was politicized.
Will the gentleman yield?
Not yet, I will though. And the point here is that, so we're taking an issue, and this is, again, this is stuff maybe nobody wants to say. It's a hard thing to vote against an amendment like that because nobody wants to be seen, and we are not, anti-woman or pro-sexual assault. I mean, come on, nobody's for that. Nobody wants that to happen. But that this could be misused, particularly we see the kinds of prosecutors and DAs that we had at that local level. And we see, yes, President Trump was an example. And again, I'm going to use the same message, give it to you what I gave to you before. What goes around comes around. That's an old New Jersey saying. I probably have in some other places too. Goes around, comes around, man. Be careful what you wish for is another one, because it could happen in reverse. Because there are some places, and I would hope as a Republican that it never would happen in a Republican jurisdiction, but where you have a strong Republican system and a strong Republican attorney general locally. And I would hope that would never happen. I don't believe it would. But the point was, why would we open ourselves up to that? And I'm not an attorney, but I've been around them for a lot of years in my state level as a state senator and over the years in politics. Is there something wrong with the federal court system? We're acting like the federal court system is useless, worthless, that they can't deal with the issue. I find otherwise. All that we want is an objective, decent, honest way of dealing with these issues that are as non-political as can be. And the bottom line, I'll wrap up with this and I will yield, is that in these days, quite frankly, some of these cities and some of these towns are more political than they've ever been in American history, ever. And we're misusing the system. And this is a way, it's a good bill to try to clean it up. I support women. Nobody wants a woman to be assaulted, for God's sake, or a man for that matter. It could happen either way, especially with the days of now transgender issues. You could have somebody that was a man that's now a very, very strong woman, I guess.
Okay, will the gentleman yield for?
I will yield, yes.
Thank you kindly, because I know of your feminist credentials, and I know you oppose sexual abuse even when the president is involved. The New York case was one in which a civil jury unanimously found that at that point the former president had engaged in sexual abuse of a woman in a department store. Afterwards, he denied it, and he said that it was a lie, it was all made up. She sued him for defamation, and she won again an $85 million verdict against him. So what part of that judicial process are you questioning?
You're yielding back?
Yeah.
So I will reclaim my time. I won't even go into that particular process. The part that bothers me in general, philosophically, we're not just dealing with one case and one president here. What we're doing is larger and bigger and more important than that. How are we dealing with the issue in its entirety and how it can affect anybody in any situation? So that's the issue here.
But your bill applies to civil and criminal.
And let me say this. There is no question, I'm sorry, I'm just gonna say it, and I know you don't agree with me, respectfully, I respect you, but there's no question when you look at the prosecutors and the attorneys general in some of these locations, they ran on saying, they ran for office, to the public said, vote for me, I am going to find a way to prosecute Donald Trump. And it could easily happen the reverse way. Nobody should run for office and say, vote for me, I'm going to prosecute a Democrat president. It's wrong. I yield back.
Gentleman yields back. The gentlelady from North Carolina is recognized.
Thank you, Mr. Chairman. So everybody's talking here about who the president is, who the vice president is, politics. I want to talk about this amendment and my support for it because of who the victim is. If you're a victim of sexual assault or rape, it is a pretty traumatic situation to even press forward with that case, to even get the evidence. I've done bipartisan work getting more sexual assault nurse examiners so that we can have somebody who has the ability to communicate with a victim of rape or sexual assault at the worst possible time and collect that evidence. If you're telling that victim now, you can't have your case heard in your community, you're gonna have to go to the federal district court. Well, in some places in this country, that federal district courthouse is hundreds of miles away. It's not in an area where that person feels comfortable. It can be an intimidation factor for that victim. It is hard enough. And imagine if the perpetrator is the president or the vice president. That in itself is a chilling situation. So we are now putting yet another block to victims of sexual assault. And I don't care what gender the perpetrator is. I don't care what political party the perpetrator is. We need to think about the effects of what we do in this committee on the victim. And it is hard enough. I have dealt with victims of sexual assault. It is hard enough for them to come forward. And now you're asking them to go somewhere outside of their community in a situation where the U.S. attorney was appointed by the President of the United States, not looking to be helpful here. That is simply unacceptable.
Will the gentlelady
This is a common sense amendment. Yes, I will yield
But
to the
if you
ranking
just yield for a question, because I think if anything, your trenchant remarks are way too charitable towards what this bill would do, because you forget the dismissal provision. Yes, the removal provision is a nightmare because the victim would have to travel hundreds of miles to go and to testify in court in the hostile terrain of a federal court where the U.S. attorney may have been appointed by the president himself. But the dismissal provision means that it's extremely unlikely that the case would ever even go to court, because it says that it would have to be proven that this would not interfere or impede with the president or the vice president's work in any way. And you're one of the best lawyers I know. Can you imagine any circumstance in which a competent lawyer would not be able to show that this would interfere with the work of the president or vice president? Because it's not just they're removing it, they're adding a new weapon in the arsenal of the president, because all they have to do is say, this is going to interfere with my work, and now you've got to show it won't.
Absolutely. And, clearly this body has not thought it would interfere with an impeachment if something had to do with sexual assault. And so why, in God's name, would we create a situation where basically the victim is left with no recourse? It is wrong, and it is irresponsible, and it disrespects victims of sexual assault and rape. And I yield back.
Gentlelady yields back. Gentlelady from Pennsylvania is recognized.
Thank you, Mr. Chairman. And I do support this amendment that would prevent removal of cases involving sexual assault, battery, or misconduct. But I wanted to point out something that we discussed in the hearing yesterday about this bill, which is Section 1456D. I think this amendment and the discussion about whether or not sexual assault, et cetera, are within the scope of duties of the president points out one of the underlying fatal flaws of this bill. So that section, 1456D, provides that no court can define or limit the scope of the duties of the president. So that means if a president were to argue that sexual assault is within the scope of duties, no court could say, no, it's not. Similarly, we saw with respect to the civil suit in New York that's been discussed, the president tried to argue that his defaming the victim in that case was somehow part of his official duties. That would prevent a court from making that determination. So I think our experts here yesterday recognized the fact that this raises serious separation of powers concerns. If a court cannot determine what the duties of the president are, can a president ever be held accountable for anything? So I do support this amendment, but I think what it does do is point out a really important, and as I said, fatal flaw in the legislation that's being moved today. So I'd yield back.
Gentlelady yields back. The question occurs on the amendment from the gentlelady from Vermont. All those in favor say aye.
Aye.
Those opposed, no. No.
I ask for a recorded vote, Mr. Chair.
Opinion of the chairs, the noes have it. The gentlelady asks for a recorded vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin? Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes aye. Mr. Goldman? Mr. Goldman votes aye. Ms. Crockett? Mr. Issa, you're not recorded. Mr. Issa votes no. Mr. Klein? Mr. Klein votes no. Mr. Knott? Mr. Knott votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 10 noes.
The amendment is not agreed to. I think we're ready for. Without objection, the amendment. Question on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no. In opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
In opinion of the chair, the ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit
Can we have a
views.
recorded vote, Mr. Chair?
Gentleman from Maryland asked, the ranking member asked for a recorded vote. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Mr. McClintock? Mr. Tiffany? Mr. Massey? Mr. Massey votes yes. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Vandrew? Mr. Vandrew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes yes. Mr. Harris? Mr. Harris votes yes. Mr. Onder? Mr. Onder votes yes. Mr. Schmidt? Mr. Gill? Mr. Baumgardner? Mr. Raskin?
Nope.
Mr. Raskin votes no. Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Moskowitz votes no. Mr. Goldman? Mr. Goldman votes no. Ms. Crockett? Mr. McClintock? Mr. McClintock votes aye.
Mr. Issa?
Mr. Issa votes aye. Mr. Fry, you are not recorded. Mr. Fry votes aye.
Gentleman from Wisconsin?
Mr. Grothman votes yes.
How many?
Two.
Gentleman from Alabama?
Mr. Moore votes yes.
Mr. Chair, I would like to impose and invoke Rule 86?
Gentleman is stating a rule. I'm not sure what he's talking about.
Rule 86 says if there's a vote during lunch, that it has to be announced
that a Tennessee
at
rule?
12:35.
Is the ranking member not providing the minority party lunch?
If the gentleman from Tennessee would like to come, we have burritos for you.
We don't have the budget for it.
Well, no, we take care of our own. So there's lunch back there for the Democrats. And you're welcome to join us, too. I think we may have more appetizing fare over on our side. I don't know.
I certainly wish you had told me, before my bill was coming up. Although we could see those and then come back to this bill. The judges. The gentleman from Tennessee perhaps noticed that there were no judges being added in Tennessee. Is that the nature of his amendment?
They might just have to remove it to state court.
Mr. Hunt? Mr. Hunt votes yes. Ms. Lee, you're not recorded. Ms. Lee votes yes.
Ms. Crockett's on her way in.
Gentlelady from Texas, recognized.
Ms. Crockett, you're not recorded. Ms. Crockett is a no.
Clerk will report.
Mr. Chairman, there are 14 ayes and 11 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I